Good morning, good afternoon. The following is excerpts from a letter dated December 26, 2011. December 26, 2011. Today's date is January 2nd, 2012, but we're reading from a letter that was written to and received by the New Jersey Attorney General Paula T. Dow, and she would have received it probably Saturday. And it was also addressed to Judge Walter Kaprowski, who would have received it Saturday or possibly tomorrow, which would be Tuesday. Um, Also addressed to Honorable Alan B. Handler, Honorable James R. Sazali, Edward J. Dalber, Esquire, Honorable Theodore Z. Davis, John J. Farmer, Jr., Miss Teresa M. Cluck, KLUCK, Ms. Alice Olick, Mr. Richard W. Roper, and Ms. Karen Thompson. Also, this letter is addressed to the Supreme Court New Jersey Advisory Committee on Judicial Conduct. Also addressed to Glenn Grant, Acting Administrator Director of Superior Court, Essex County, in his capacity and as an individual. Also addressed to Judge Walter Kaprowski, Vanessa D. Taylor, Lawrence Myerson, Shonda M. Floyd, James Boudelier, Elisa Johnson, Letitia Johnson, Vernell Johnson, Kevin Johnson. And we'll be quoting from parts of this letter. And this letter was written by next of kin, oldest son of Robert Johnson. Of course, Robert Johnson is the ward in the guardianship case CP 01362009, and Robert Johnson is currently in the Woodlands Nursing Home in Plainfield, New Jersey. Quoting from this letter, "This was a well-designed plan of the judge in collusion and a well-oiled practice of the probate courts to limit and extinguish the rights of the pro se litigant and intended beneficiary of the estate of Robert Johnson. It is an institutionalized practice of the courts, admitted by Judge Kaprowski, to maintain a separate and unequal court system under color of law. Is this what you call equitable, or is this what you call the torture chamber of Auschwitz, New Jersey?" Again, quoting from the next of kin, oldest child, quote, "I feel one reason why the court is engaged in this well-entrenched conspiracy of silence and concealment is because of the elderly financial abuse of the ward by guardian Vanessa D. Taylor and others. The inventory report submitted by Vanessa D. Taylor should include the amounts of the ward going to Vernell J. Johnson on a monthly basis," unquote. And of course, the annual report submitted by Vanessa D. Johnson Taylor does not include the monthly amounts going to Vernell J. Johnson, and there has been no explanation why by the guardian, nor has there been an explanation by the court. Quote, "This case has not been about facts or law on the judge's part. It is only about the judge's own personal agenda to act in his own personal pursuit, devoid of fact and law, and outside of his authority, discretion, and immunity. All documents of the oldest child stricken from the record by the court evidence, quote, the judge's bias, unfairness, partiality, and failure to act honorable and fair in one's dealings and actions," unquote. The March 28, 2011 order of the court, quote, "is an injustice and a, quote, a threat to injustice everywhere," unquote. It is evidence of the continuing concealment of evidence of the court, fraud on the court, inability to perform duties of the judge, the medical issues of the judge, and evidence of the judges both acting outside of their judicial immunity. Judge Joseph Brennan and his successor cannot uphold or follow the March 28, 2011 order, as the order is unconstitutional, and to follow it is a violation of the oath of office of Judge Joseph Brennan and any successor. And again, we're reading from a letter December 26 to the Attorney General of New Jersey, Paula T. Dow, and also received and mailed to others, referencing the guardianship case of Robert Johnson, Chancery Court, Essex County, New Jersey. I'm going to read here from a section entitled Auschwitz. And of course, Auschwitz is the concentration camp in which the Nazis decided to exterminate various members of different nationalities. But this is a section of this letter entitled Auschwitz. The judge claims in a November 3rd letter, and he's referencing a November 1st letter of oldest child of the ward, quote, that I have accused the Chancery and Surrogates Court of, quote, wrongful conduct, vandalism, discrimination, and collusion, unquote. That's what the judge says in his letter. The judge says that the suggestion that the court change its name to Auschwitz have willfully directed language to the court which clearly creates a threat to the conduct of orderly proceedings, unquote. And the oldest child says, I disagree. The oldest child says, my intent was to act in good faith, and I had no intent, nor did I engage in any threat to the conduct of orderly proceedings. It seems to me that the only one making a threat is the judge. He says, quote, if you continue in this disrespectful conduct, you will be cited for contempt and appropriate punishment will be assessed, unquote. Quote from the oldest child, yes, like when you assess sanctions on me before without warning, and the required order to show cause without the required order to show cause. I have every right to wonder if you will lock up and lynch every relative of the ward who seeks their constitutional rights. I have every right as a citizen of the United States of America to petition the government for redress of my grievances, and to do so without the threat of retaliation from a judge acting under the color of law, unquote. And that's in a letter December 26 to Judge Walter Kaprowski, and also to the Supreme Court Judicial Advisory Committee on Judicial Conduct. I'll continue reading from that letter. Quote, by the judge's conduct, he has disbanded his oath, refused to recuse himself, and acted outside of any authority or immunity. If one studies history, Auschwitz was indeed wrongful conduct, vandalism, discrimination, and collusion. The judge has the opportunity, but he never denies that he and his staff and the surrogate judge and staff have indeed engaged in, quote, wrongful conduct, vandalism, discrimination, and collusion, unquote. Quote, Vanessa D. Taylor and officers of the court, Shonda N. Floyd, James Boutelier, and Lawrence E. Meyerson, have admitted the, quote, wrongful conduct, vandalism, discrimination, and collusion, unquote. Why does not the judge threaten them with punishment? Because he is unlawfully acting as a private citizen outside of his oath, judicial duties, and immunity. It is not disrespectful for the oldest child to question the oath and duty of a government official who cannot act, quote, faithfully, impartially, and justly to the best, unquote, of his ability. At Auschwitz, quote, they took people's lives and property without due process, like the judge taking my father's property and my money. They took people and isolated them from their relatives, like the court isolating myself and Dr. Anderson from information on their relatives. They denied them access to the courts, like you deny myself and Dr. Anderson access, and denied them fair and full opportunity to be heard, like you have denied myself and Dr. Anderson. I presume at Auschwitz they thought they were being equitable and fair, although the trials at Nuremberg disagreed. Is it equitable and fair, Your Honor, for you to make things financially burdensome for me because, as you say, I do not have an attorney? The United States Constitution guarantees me the right to represent myself without an attorney. Quote, is it equitable and fair for me to be assessed fees for something that I never did? Is it equitable and fair to attempt to take my property, money, and fees assessed without due process? Why is this not like the torture chambers of Auschwitz? Why is this not the same as a public lynching by you acting under color of law? Again, we're quoting from a letter December 26, received by Judge Walter Kaprowski and also by the Attorney General of the State of New Jersey, Paula T. Dow. I continue with this letter in reference to the case CP 01362009. It's a guardianship case in the state of New Jersey. This is again the oldest child of the ward speaking in the letter. Quote, there are federal, state, and local taxes owed on the property, as well as attorney fees alleged, according to Taylor's past accounts, but none of this is spelled out in her complaint. Fraudulent concealment voids her complaint. The words "as is" needs to be taken out the contract, as it represents intentional fraud and fraudulent concealment by the guardian in the court. Unquote. In the contract that Vanessa D. Taylor has presented, she says that the property is being sold as is, subject to repairs and the payment of state and local taxes. However, in documents to the court, the guardian and James Boudelier represent that the estate is to give a credit to the buyer of about $58,000. So the property is not being sold as is if you're offering them a credit. So it has to be one or the other. Either you're giving them a credit for $58,000, which the next of kin has disagreed with, or either you're just going to sell the property as is, and the person is responsible for all the repairs. But you can't say the property is being sold as is, and then you're giving the person outside of the contract a $58,000 credit. That's misrepresentation. Let's see what else we have here. And again, this letter was written December 26, 2011, and it's in reference to a contract of sale that is proposed by Vanessa D. Taylor and supported by James Boudelier, who is an attorney, and supported by Shonda Floyd, who is an attorney, in spite of the fact that the complaint itself does not comply with the applicable rules of court, and the judge is quite aware of it. The judge is accused of intentionally concealing pleadings from the record, and there's at least one document that the judge has persistently excluded from the record, and that was the first opposition to the sale of the property. And the judge is aware that his office, he stated April 6, 2011 in a letter to the parties that an original copy was served on him, and I believe a month later the records show that his office accepted an additional original copy of the opposition to the sale of property, and yet the judge has been very quiet as to where are those two original documents, which over a year later the court is not willing to reveal where those documents are at. Also quoting from the December 26th letter, quote, I noticed the 203K HUD loan states $9,000 needed for appliances. That seems to be an exorbitant rate, even including the cost of installation. Certainly if the guardian indicated in the past affidavit that the buyer would do his own repairs and save on labor costs, he does not need to be unjustly enriched by an additional repair credit at the expense of the ward and the intended beneficiaries. So you see that the judge has participated in spinning down the value of the property in order, and not in order, but in addition to giving a credit to the proposed buyer, who also happens to be a friend of one of the attorneys and also happens to be a fellow attorney. The attorney and the judge in this case have embraced the feeling, this is what they've stated in writing, that only attorneys have the wherewithal, that was the word they used, the wherewithal to purchase any type of property. So of course, that couldn't possibly be true unless you live in a very prejudiced world, which says that only attorneys are entitled